Well, big developments in court today.
Closing arguments are now expected tomorrow in the trial of Blendon Township police officer Connor Grubb.
Grubb is charged with murder in the death of 21-year-old Takaya Young, a pregnant mother accused of stealing alcohol from a Kroger store back in 2023. The big news out of court today, the judge dismissed charges involving Young's unborn child.
We have live team coverage for you tonight. Let's start with 10 TV's Lacey Crisp. She's been in court every day of this trial.
And Lacey, why were these charges dismissed?
Well, the defense argued that Grubb did not know that Young was pregnant at the time of the shooting. The judge agreed and dismissed those charges. This came after a heated exchange with the state's last witness.
Hey, you're not free to leave right now because here I am standing in front of you like a human traffic cone. Maybe no increase in tactical benefit, and again, exposing officers to a substantial amount of risk.
Professor Seth Stoughton was the last of 17 witnesses to testify in the murder trial against Blendon Township police officer Connor Grubb in the death of Takaya Young.
Why would you put yourself in the position of being exposed to that degree of danger? Just stay out of the way.
In August 2023, a Kroger employee flagged down Grubb and another Blendon Township officer, accusing Young of stealing alcohol. The officers confronted Young while she was inside her car. She did not listen to commands. Instead, the car moved forward with Grubb in front of the Lexus. Grubb fired one shot, fatally wounding Young. Her unborn baby also died.
Your second opinion is that he should have used a different tactic to get out of the way of the vehicle.
Yes, that his tactic of remaining in front of the vehicle and drawing his firearm was professionally inappropriate, yes.
But the law says that what an officer could have done is comparative speculation.
Stoughton has testified as an expert in dozens of cases across the country, including Derek Chauvin in Minneapolis and two others in Franklin County involving Jason Meade and Adam Coy.
Connor Grubb has to enforce Ohio law, sir, correct?
Sure.
Okay, and you didn't review that Ohio law before coming into court to testify today, yes or no?
That's correct, because it wouldn't matter to my opinion.
Thank you so much, sir, for telling me that Ohio law doesn't matter to your opinion.
Stoughton testified by standing in front of the car. Grubb was not justified because of officer-created jeopardy.
And how is an officer standing in front of a vehicle, how does that relate to the concept of officer-created jeopardy?
If an officer steps in front of a vehicle when the tactical risks substantially outweigh the tactical benefits, we'd say that is not justified risk-taking. And the term of art that we might use there is that's an example of officer-created jeopardy.
The defense argued Stoughton didn't apply Ohio law.
You live in South Carolina.
I do.
And more than 20 years ago, you were a police officer in Florida.
Correct.
But you're here today to talk about what a police officer did here in the state of Ohio, true?
Yes.
And as a paid opinion witness, you've already admitted to the ladies and gentlemen of the jury that you don't know a lot about Ohio law, right?
I do not apply Ohio law when I'm here as an expert to talk about generally accepted police practices.
Now, tomorrow morning, Judge Young will give instructions to jurors. Then both sides will give their closing arguments. Then the case will be in the hands of the jurors. Reporting live, Lacey Crisp, 10 TV News.